Hi, it's Chris Jackman. Welcome back to a Father's Rights podcast. In today's episode, I want to talk to you about the most common mistakes that I see fathers and men make in their divorce or make in their family law case, because I've seen all of them. And I want to touch on a few of those because I don't want you to repeat those, because, it's one of these things where in family law cases, it's always, I shouldn't say always, it's often possible to unwind mistakes that have been made. In some areas of law, there's this thing called the statute of limitations, and that's how long you have to bring a case. In those situations, if you blow past that, nothing you can do to unwind it. The case is over, it's done. But in family law, there's ways that you can fix things. You can file appeals. You can file what's called a motion, which is a document to the judge asking for something to be fixed. But here's the problem, is that when that happens, number one, it's going to cost you a lot of money, because now you got to pay your lawyer a lot of money to go back and try to fix these mistakes. And number two, it just doesn't look good for you as the father and for your lawyer, because now you've got this permanent record and you're trying to undo it, and judges are like everyone else. They don't like going back in time and trying to fix mistakes that were made, and especially on appeals. I often have clients who want to do an appeal because they feel like the judge made a bad decision, and that may be true, but as you can imagine, these judges know each other. They go to lunch together. They go to conferences together. So trying to get your judge or judges to do an appeal and fix a mistake is often, or I shouldn't say always, but it's often very difficult. So rather than have to go back and hire a lawyer to fix something that was done, just do it right the first time. And a lot of that starts with the client, to be very candid with you, in terms of how the client approaches their case. And I want to give you the number one mistake I see clients make, and that is procrastination. Procrastination is the number one mistake I see clients make, because they just, and a lot of the time, it is simply just a refusal to acknowledge what's going on in their relationship and their life. And I totally understand that, because when you're faced with a massive change and the end often of a relationship, you want to deny it. You want to put it off for another day and think it may get better. But normally, if you're at the point where you have been served court documents, or the discussion with your partner, your spouse, has gotten so grave that they're talking about divorce or talking about a split, it's going to be hard. It's going to be really hard to fix that. And I get calls a lot from men who are in situations where they're giving their ex another chance, or they're trying to work through it. And often what I see, unfortunately, is that those relationships just don't survive. And so number one is just, like I said, procrastinating, especially when you get served legal documents, because there is some advantage to being the one to actually file the documents first. And you might be wondering why that is, because a lot of times my clients are on the receiving end. And actually, if you look statistically, it's actually much more likely that a woman, the wife, will be the one to file for divorce or file for custody. It's something like 75% of the time that that's what's going to happen. So just be aware of that this happens to you, that you actually receive court documents from your spouse. You're not alone, because most men are on the receiving end of that. And so, when it comes to the advantages, the number one reason why you should be the first to file, if it does look like the relationship is over, is that ultimately, if things do work out, you can dismiss that case. You can actually get rid of that case, right? But you can't do that, obviously, if you're on the receiving end, right? So number one, you're kind of in control more if you're the one filing those documents. And if you look at the documents that you get, you only got 20 days to respond, right? So you don't have a lot of time, and you need to get that response timely filed with the court and with your spouse or your ex, so that way you can get your case going. Because otherwise, it's one of those things where you may want to delay the inevitable, but it is inevitable. And I've noticed that the longer that delay takes place, a lot of times the harder it is for someone to get over that relationship. And obviously, you never want to rush something that's as catastrophic as losing a marriage or losing a relationship with a parent, but at some point you have to do it, right? And number two, I would say that the number two mistake I see men make in their cases is trying to play hide the ball. You know, as you can imagine, a lot of times what I see with my clients is I see requests to try to get my clients' financials, right? Because the number one thing that men normally worry about in their cases is, am I going to lose visitation or custody of my child? The number one reason a lot of women have in their cases is, am I going to be able to financially support this child on my own? And so as you can imagine, what a lot of women are going to do is they're going to try to get access to your financials. And a lot of clients, unfortunately, think that they can play hide the ball, that they can just refuse. I had one client who just absolutely refused to hand over his brokerage accounts where he had stocks. He refused to hand over the bank accounts or the information regarding his bank accounts to the opposing counsel. And it got really bad. When I say bad, like it got to the point where my client was actually dragged into court. I was with him, and I didn't want to go with him, but obviously I went with him because, and I'll get to why I didn't want to do this in a moment. But the judge eventually ordered it, and then it eventually got to the point where the judge threatened to put the guy in jail, my client in jail, if he didn't cooperate. And I think that's the part that's hard for a lot of men to understand, is that, you know, when this process starts, it's called the discovery process of the case, and it's just what it sounds like. It's discovering the financial aspects of the case. It's not a voluntary thing. As much as you may hate it and you may resist it, it's not something that even the greatest lawyer in the world can throw. Now, a good lawyer can put roadblocks up, certainly. You know, we can object to things, but at the end of the day, if spousal support is requested and if you have a child, you have to pay child support. And that child support is going to be determined simply by how much money you and your spouse are or are not making, right? And so you've got to turn those numbers over. And I've tried with a lot of my clients to make them understand that. And sometimes it falls on deaf ears. And what it ultimately does is it just makes the client's case drag on even longer than it should. And worst of all, it makes the case a lot more costly for the client, because number one, you know, the client's got to pay for my legal fees that I charge by the hour. And number two, if the judge decides that my client has been acting in what's called bad faith, you know, meaning intentionally trying to play hide the ball with financials, it's very likely that the judge is going to order my client to pay the other lawyer's legal fees. And there could also be things called sanctions, which is basically just a money punishment, you know, and that could be a few $1,000s or it could be tens of thousands of dollars. So the consequences are severe, you know, in terms of that. And the truth of the matter is, if you have a good lawyer can usually find creative but still very much legal ways to frame your financials in a way that's not going to overexpose you, so to speak, to exorbitant amounts of spousal support or exorbitant amounts of child support. A good lawyer is going to be ethical and find exactly how much should be paid, but it has to be paid. And I think that's the message I need to send, is that this is not something that we can play games with and just hide and hope that it doesn't come out, because at some point it will, you know, and a lot of times my clients don't understand that even if the only issue they're trying to solve, or the only reason why they're hiring me or a lawyer, is to get more visitation or more custody, if child support has not been determined, it will be, as part and parcel of the visitation or custody case. So even though you may think you have a very narrow, specific thing that you're trying to accomplish with getting visitation, you can't avoid the child support part. And another thing that a lot of clients don't realize is that, you know, not paying child support or at all, or not paying enough, is actually a crime. And what you're actually going to do is you're going to subject yourself to a criminal prosecutor. That's right. These are the same kind of attorneys who prosecute murderers and rapists and burglars and all those things. There's going to be there is a division of the prosecutor or the district attorney's office who goes after people who don't pay child support or don't pay the proper amount. And, you know, you're really just delaying what could be very painful, because you could wake up someday and find that your paycheck has been garnished or that your bank accounts have been drained, because, as you can imagine, the government does have the ability to find your accounts. Unless you're offshoring your accounts, which, you know, you obviously don't want to do because that's illegal, eventually, now, candidly, it may take a year, it may take 2 years, but it's one of those things where you can run, but you can't hide. And I can promise you that a prosecutor or opposing counsel who's motivated, they're going to find those accounts, they're going to find the money. So again, it's a friend of mine is a criminal defense lawyer. And he often tells me, Chris, it's frustrating when my clients don't submit to a breathalyzer, because at least I can challenge the breathalyzer test, because sometimes the test wasn't administered properly or the cop made some procedural errors. But he's like, if my client just refuses to cooperate, period, then at least in the state that my friend's in, license gets revoked and there's a presumption of guilt, right? Because you refuse to cooperate, right? And that's the law in that particular state. And it's kind of the same thing with child support or with spousal support or turning over the financials. If you just refuse to cooperate, there's nothing a lawyer can really do to try to angle it or massage it in a way that's favorable to you. There's just going to be a blanket presumption that you're hiding things and the truth is going to come out. So that is by far and away the number 2 most common mistake I see. The third most common mistake that I see over and over again is what I kind of view as a lack of objectivity. And I know it's hard to only or to step outside of your shoes and see things through possibly a judge's perspective, because I think outside of Texas, every state has a judge view or make decisions about custody and about your family law case. And my understanding is that even in Texas, it's very rare that a jury is going to make any decisions. So it's the inability a lot of times for my clients to kind of see things through the judge's eyes. And it's hard. We all suffer from a lack of perspective sometimes, but I think it's critical that you're able to do that and to see how the judge is likely going to view your case, and not simply seeing this for what you believe it to be, but actually how it is. And if you have a good lawyer, what they're going to do is they're going to tell you what you need to hear and not what you want to hear. And those are very different things. And early in my career, I struggled with that because I thought I needed to tell my clients what they needed to hear, or what they wanted to hear rather. And as time went along, I got better and better about, on the one hand, advocating for someone, but on the other hand, being as neutral as I could and telling them, I don't think this is going to work out for you in the way that you hope. I think you need to settle now. So as difficult as that is, I think that's something that people lack is a perspective on how things are going to turn out. And just having this sort of hope and a wish that things are going to work out when they often, unfortunately, don't. Number 4, the most common mistake I see is going to trial. And a lot of times what I see in my clients is that they go into what's called a mediation. And so just to give you some background on this is that after you go through the whole process of figuring out financials, maybe you do some interviews with people, you'll have to do in most jurisdictions what's called a mediation. And it's just a sit down where a professional mediator is hired. This is normally a retired judge or a very experienced attorney. And that person's job is just simply to pass some offers back and forth. Offers for whatever. It could be for how often you're going to see your child. It could be for how much you're going to pay in child support or spousal support. And what I often see from my clients is that they say, all of these offers are terrible. Trial must be better. Because the trial is the unknown, right? It's that thing that's out there. And since nobody can give you an absolute certainty of what's going to happen, it's like the human brain just defaults to the unknown automatically being better. And what I often see is that that's not the case, that even though that option of going to trial is unknown, it's often either exactly the same of what the offer is at mediation or possibly worse. And I can tell you there's no worse feeling as a lawyer than going into trial after you've told your client what's likely going to happen, and then that thing that you predicted happening and that thing not being good for your client's case. That is a hard conversation I have with my clients, and I feel terrible, because we had the opportunity sometimes a week before, or it could be 3 months before, to settle the case, to prevent people from going to the trial, which, by the way, it's called a trial for a reason. It's a very trying experience. It's not fun for anybody. And it could be a day long or it could be 3 months long, but it's going to be very expensive for you, and it's going to be stressful because, again, you were dealing with the unknown, and you were dealing and often unearthing a lot of emotions and a lot of very private things with a courtroom, right? With a judge and with a judge's assistant. And you have to be in the same room with your ex, hashing out and reliving a lot of things that you frankly probably don't want to have to talk about and relive. So, it's not to say that you should never go to trial, but it's just an understanding that trial may not be the best option for you. And I often tell my clients that it's often not the best option, and that you shouldn't just by default think that going to the trial is going to be the best thing for you. Because normally settling your case at mediation is the best option. So again, those are the 4 most common mistakes that I see. The fifth, and it's probably a little bit lesser of a mistake I see, but it's certainly a mistake I see, and that's just hiring the wrong lawyer. A lot of times people will hire based on cost, but I can tell you that it's really a relationship that's likely going to last at least a year, maybe longer. And so I think when you're sitting down with a potential lawyer or having a phone call or a Zoom interview, you want to make sure that this lawyer, whoever it is, and regardless of whatever their credentials are, this is someone that you trust, that you kind of like, at least on a human basis, that you can get along with this person, because you're going to be spending a lot of time with them, either on the phone or in courtrooms. And if you just don't feel like this person's a good fit for you, it's going to be tough, and you're probably going to always have some nagging doubts in the back of your mind if things don't go well, that is it the lawyer's fault, or is it my case, or is it any number of reasons why things aren't going in my favor. But if you feel like you've got the right individual in your corner, you're probably not going to be second guessing yourself that way. And so I would really make sure that you're just trusting, and this is one of those things where only you can decide whether it is a right fit, but you just got to make sure if this is a good fit for you, that the lawyer, and if they have a paralegal, the paralegal as well, are really advocating for you, and you feel like they have your best interest at heart. So I hope that these common mistakes are ones that you don't make. If you have any questions or you want to talk about your case, feel free to give us a call.